You or a loved one have been charged with or convicted of a crime, you need an aggressive and effective defense attorney to help level the playing field and increase your odds of success. At Hall Scott McGarrow, we have over 55 years of combined experience in criminal trial defense, appellate litigation, and post-conviction litigation. After a person has been convicted in federal court and sentenced to federal prison, in some cases, that person may be able to get bail pending appeal, or sometimes called supersedeas bond. The process for getting bail on appeal is very complicated. First, the person has to make a motion to the federal district court where they were convicted, asking the federal judge to grant him or her bail while the appeal is pending. If bail is granted while the appeal is pending, that person can remain out in the community under the supervision of either pretrial services or federal probation and remain at liberty until their appeal is finally decided. Getting bail in a federal criminal case is never easy, and getting bail after a conviction is even harder. In order to qualify for bail pending appeal in a federal criminal case, Rule 38 of the Federal Rules of Criminal Procedure sets out the qualifications that a person must meet in order to get bail. Number one, the defendant must show that they plan to raise issues on appeal that have merit and are likely to succeed. What that basically means is they have to be able to show that when they appeal to the Federal Court of Appeals, the Court of Appeals is probably going to reverse their conviction. The second requirement is that the person has to show that they are not a flight risk. And that basically means that they have to show to the court that if they are granted bail, there is very little risk that they will flee the jurisdiction, become a fugitive, or go on the run. The third qualification for getting bail pending appeal is the defendant must show that they are not a risk to the community. They're not a dangerous individual, they're not at risk of committing further crimes while on bail, and that the community will not suffer if that person is granted bail while their appeal is pending. Filing a motion for bail pending appeal is extremely complicated. You basically have to do at least half of the entire appeal up front in the motion. The lawyer will have to identify the issues to raise on appeal, do the appropriate research, and argue successfully that there is a likelihood, a strong possibility, that the appeals court will reverse that conviction, that they will be victorious on appeal. These motions are never simple. And whether a person spends the next 12 to 18 months in jail while their appeal is pending, or whether they're home with their family, can make all the difference in the world. Needless to say, it's much simpler to represent a client who's at home with their family, able to work and live in the community while their appeal is pending. It's much harder on the person, on their family, and on the attorney when that person is in jail for 12 to 18 months while their appeal is pending. If you want to maximize your chances of success in getting bail pending appeal, hiring the right attorney who's experienced in these matters makes all the difference in the world.